now. So, but I think I should conclude it within an hour and a half or maybe a little.
If you can try by 11:30 today, so that then we'll give Mr. Datar.
I'm
Now, what is the lineup? It's basically you, followed by that, Mr. Datar. 10 minutes for you. So the two major arguments now are by Mr. Dwivedi and Mr. Datar. By Jaideep Gupta. How long will Mr. Gupta take? Is it possible for all of you to wrap up by lunch today, so that, you know, if this side, Mr. Datar, about, and if what I was thinking was that maybe if Mr. Dwivedi concludes at 11:30, then we'll give Mr. Datar till lunch, so you'll get about an hour and a half, and then maybe an hour after lunch for everybody together. So by 3 o'clock, this side can get over, and then the solicitor and the attorney can start at 3 o'clock today, so that. So we'll wrap up by 3 o'clock tomorrow on this side, and then we'll have one rejoinder from all of you. All of you can sit down together and see who will do the rejoinder. One rejoinder for 1 hour tomorrow, and we'll close tomorrow evening.
Not with due respect, Lordship should, but I would request Lordship not to ask us to combine together, because that never happens. Invariably, Lord, everyone wants to say his own kind of thing, which he has up his sleeve.
We are doing all other benches. All other CBs, we have had one rejoinder, and others may give a small note of a page or something. Perfect. So that there'll be one rejoinder. And if you feel that anything else has remained, one-page note that, well, these are the major points which we wanted to highlight to supplement what Mr. Dwivedi has argued. Because rejoinder really should be one.
Only one caveat. Concluding it tomorrow may perhaps not be possible. There are two reasons. A, the Lordships would find in all these judgments, the argument is this judgment was not cited, that judgment was not cited. Listen, we would not like to be accused of not citing everything. And number two, 9-judge combination sits rarely. If we cannot cite some judgment and lack of assistance results into something, that might. But will not repeat anything, will not be irrelevant. And my submissions would be other than what they have already argued, rather than dealing with it.
All right.
And my lords, apart from attorney and solicitor, there are private parties also. I'm representing them.
After the attorney, but you are supporting them.
Yes, ma'am.
Something
Whatever,
you can give us
whatever is left, I'll cover.
Just a one-page note or something. The others, after the attorney and the solicitor, a one-page note by all of you. Tell us what the points are which have been left out.
I think others means he is the only one. Our team is smaller.
No. We have filed the written submissions. That's
Yesterday I was seeing Mr. Abhimanyu
attorney, followed by me and Mr. Agarwal, my lords.
So keep a one-page note ready, so that we can then we'll be time. Of course, we'll hear him. No difficult. It's a pleasure to hear all of you. But just keep a one-page note ready.
I would curtail my submissions, my lord. But kindly give 10 minutes each to, my lord, the colleagues who have really prepared well. They wish to address your lordship. I would wish them to address your lordship.
Certainly.
Brilliant young people.
Also. Yes, Mr. Dwivedi.
Kindly recall the question which Lordships had. That question, I must confess, has given me some sleepless night. Therefore, I need to elaborate on that. But the question which Lordships had posed was that intoxicating liquor contains various items on which regulations can be made, like manufacture, production, supply, distribution, transport, etc. So virtually everything with regard to intoxicating liquor. This is irrespective of whether it contains potable liquor or industrial alcohol. Apart from that, then Lordships felt that even entry 52 contains the same thing, and therefore there is a conflict and a clash. If Lordship would kindly have entry 52 again for a moment.
Yes.
Does it contain the same thing? That's the issue. And is there a clash?
By
That's the issue.
interpretation, it has been held to contain the same thing.
No, I'll answer that. No? Is there a clash? That's the question eventually. Entry 52, list 1. Industries, the control of which by the union is declared by parliament by law to be expedient in the public interest. Now, whether we can read this word control so compendiously and expansively as to include everything that is contained in entry 8 note, that's the issue. Because if it does not, then there is no conflict. This will also entail the question, Lord, whether industry here is so expansive as to cover sale, distribution, transport, etc. Trade and commerce. Will it include bird control? That's it, of industry. Now, Lord, when we compare the two entries, entry 8 list 2 and entry 52 list 1, there is a vast difference in the language. There's one aspect, Lordship, note. Because lots of things would turn on the word control, whether they include whatever is included in entry 8 or not. That's the question. None of the cases, Lord, none of the cases which I had cited up till ITC come to this conclusion that the word control is as broad as what is included in entry 9. Supply, distribution, trade and commerce, everything, it's not there. There's a considerable unanimity from 1956 onwards till 2002. At least 7 constitution benches would say, if you have to see this expanse of this scope of this entry 52, you must see entry 52 is by itself not a field of legislation. It becomes alive only when a declaration is made with regard to an industry. Then that industry is transported from entry perhaps 24 and comes to entry 52. So what is the source, I ask myself? The source of the power of the field is entry 24 exclusively. Lordship would recall that statement in Ishwari Kehta, Justice Krishna Iyer, Constitution will say, only from entry 24. So whatever is dragged out of 24, that comes to 52, nothing more. So there are two ways of looking at it. One, when we want to see the expanse of the word industry and control, then we must go back to the source, which is entry 24 list 2. Because whatever is contained therein can possibly come here. Entry 52 cannot drag more than what is there in the well or the source. And entry 24, Lord, has been analyzed in at least half a dozen cases. One was which I had cited in a very limited manner, but I just need to place that judgment and then that will answer Lordships. Now, Lord, question is this word industry in entry 24, what is the expanse of that? Because as Lordship has seen, all the cases are unanimous that word industry in entry 52 would mean the same thing as entry 24. There is a intricate and intimate link between the two, Lord, which cannot be snapped. Now, Lord, if word industry here is of limited expanse, then we can't expand the scope of entry 52 beyond industry in entry 24. Now, let us see, Lord, the scope of entry.
Tikaramji says that industry industry covers 3 elements. One,
yes, widely,
raw
in a wider way, it covers 3.
Raw materials, manufacture or production,
Right.
and distribution.
Right.
It says that raw materials would not be comprehended within entry 52.
Because they're not part of
Industry. Then, second, they say
The end product-
manufacture or production would also not be covered unless it is a controlled industry. Once it is a controlled industry, they say
With due respect.
manufacture or production will also be covered by entry 52. But they say that even in respect of a controlled industry, distribution of the products goes to entry 33.
My lord.
So, in your favor, in case a industry is declared as a controlled industry, the distribution of the product goes to the concurrent list. In the concurrent list, unless there is a legislation by the center which prohibits the states from
Come to
enacting a
that
law,
aspect, not little later.
the states are not
That's the
excluded.
B part of my argument.
Therefore, for instance, you can certainly levy a fee in relation to distribution is concerned.
But the difficulty that is arising, with due respect, if I can explain, is because we are trying to trace the word industry in all its expanse on its own. But what the case law from 56 onwards till date indicates is the word industry takes its color and scope and expanse and depth and breadth, whatever it is, not from entry 24. Now let us see what is there at the initial stage, what is there in entry 24 which can be taken over.
You know, if you go to Tikaramji again, which was what we read yesterday at volume 5, page 96.
I mean, let me kindly bear this fact in mind. In Tikaramji, the issue was of entry 33, not for the product of notified industry. Tikaramji is different. Tikaramji was a case of entry 33 because there was an entry containing foodstuff over there. And therefore, it became it fell within entry 33 list 3. Not because it was product of notified industry. Sugarcane was never regarded as product of notified industry. Your Lordship, may I have entry 33? For a moment. 33. This 3. Trade and commerce in and I'm sorry. (33A) relates to product of industry notified under IDR. B relates to foodstuff, and sugarcane was traced to foodstuff in Tikaramji. And therefore, they said there is an express entry here for foodstuff, therefore it won't go to industry. So Tikaramji is being misunderstood with due respects here, because Tikaramji is not a case of product of notified industry being regulated, but instead raw material of the industry, which is sugarcane. So when Tikaramji segregated the end product as well as raw material, it first went to entry 24. And therefore, what I am submitting with respect is kindly go to entry 24. And then let us carve out what is included in entry 24 in the state list. Because as I said, source is entry 24. If the source doesn't contain something, then perhaps you can't expand the source by taking it over in entry 52. Now kindly have entry 24.
Argument, basically, we've got the point that your argument, we'll have to hear the other side of that, is that this product relates to entry 8 of list 2.
Completely.
Right.
You don't have to go to entry
step 1. Once it relates to entry 8 of list 2, it does not fall in entry 24 of list 2. Point number 2. 3, if it doesn't fall under point number 3, the concept of industry in entry 24 is the same as entry 52, or rather entry 52 industry is the same as entry 24. So 4, since entry 24 is not applicable, likewise, therefore, entry 52 is not applicable.
Exactly. With due respect, I'm grateful.
That's really the 5 points which you have made. And really speaking, the whole fulcrum of your submission depends on whether industrial alcohol is an intoxicating liquor within the meaning of entry 8.
Exactly. And for that
Because that's the first and foundational argument which you have
I'm
made.
extremely obliged. Not I had to work whole night on this, but lordships have really taken it.
So
I'm-
these are the 5 steps which you have built your whole argument on.
And this would be clear.
And you say that industrial alcohol is intoxicating liquor by saying that, well, you must bear in mind the past legislative practice, the provisions of the Government of India Act, entry 31, and how it was interpreted by the courts,
Exactly.
the 2 British acts, which Balsara said you must look at.
Look.
And therefore, Balsara says, according to you, that industrial alcohol intoxicating liquor would include liquor fit for human consumption as well as denatured spirit. That was the broad Balsara.
Here, Your Lordship, may I add 2 more decisions
Just,
relating to
One more addition to that, industries is basically a state subject.
State subject.
52 is bio of exception.
Now, Lord, here, Your Lordship, may very kindly add 2 more decisions, Lord, relating to denatured spirit and industrial alcohol, which were held to fall in, Lord, intoxicating liquor under entry 8. One is perhaps not the Southern Pharmaceuticals.
Give us those apart from Balsara.
Yes. Southern Pharmaceuticals. Southern Pharmaceuticals, PDF page, volume 5,
What is the citation?
1981, volume 4, SCC 391. The relevant paras are para 6, 12 to 14, and 17.
How many judges is Southern Pharmaceutical?
This is, I think, 3 judges.
I think just the AP Sen's judgment, right?
I'm sorry?
Is it just the AP Sen's judgment, I think?
No. I'm sure. Your Lordship is right. No? It is Justice AP Sen's.
That's the classical judgment on
That's
fee, tax and fee, I think.
Yes. That is a different judgment.
That's a different.
That's Hext
Not this,
Pharmaceuticals.
that's not this one. All right, that's Hex, you're right.
That's-
That is
That's
83
83, this
Supreme
is Southern, yes.
That's Hex one. But that judgment, Lordships, may have a look into it, for with due respect. For this reason, not what was troubling Lord Justice Nagaratna was the notwithstanding clause. It has been beautifully explained in that judgment, because this clause was there in Section 100 Government of India Act, from where we have borrowed this. So it has been beautifully explained there.
Southern Pharma also says that intoxicating liquor includes
Not that.
industrial alcohol. What does
There,
that
a
say?
rectified spirit was being used for manufacture of medicinal and toilet preparations. So they said it comes within entry 8, intoxicating liquor. And the next is perhaps what Indian mica and mechanite. It's a constitution bench judgment. 1971, volume 2 SCC 236.
PDF page 5. PDF page 5.
It's a PDF,
Page 5, volume 5.
page 5, volume 5.
The earlier judgment, where do we get it in volume 5?
1985. 18. PDF page 1985.
PDF page 1985.
And in the second judgment, which is the relevant para?
Yes. Paras.
And just give us the PDF.
I'll give the relevant paras. Para 3 and 12.
Page.
PDF page 7,
5A.
volume 5A.
5A.
Ma'am. So these 2 judgments, Lord, further elaborate on this and accept the contention.
Quickly, those 2 judgments. Let's have a look at those 2 judgments,
Well,
because one is just for CB, so
yes.
You can see the CB.
let's see first, and then we'll just quickly
1971.
glance through the next one. First one was second is 5A. 5 hai, so we'll go to page 1985 for a moment. Para 6 and 12 to 14, right?
Can you have para 3, Lord?
Of Justice Sen's judgment, right?
Just a sense judgment. एक days just to say एक days. This is 71, but we've gone back
71.
as far
All
back
right.
as 71.
Just give us a minute. I'll just go to volume 5A. 5A, no?
5A.
5A page. What's the page at page volume?
Volume 5?
A,
A.
PDF page 5.
Volume 5A, PDF page 5.
Yes.
Paragraph 3. No? Page 7 of the PDF. No? The appellant is a consumer of denatured spirit. It purchased denatured spirit from the wholesalers or the manufacturers for the purposes of manufacturing maconite. The Bihar and Odisha Excise Act 1915 came into force on January 19 and January 19, 1916. In pursuance of the provisions of that act, the impugned rule was framed by the Board of Revenue for levying license fee. The fee for the license to possess denatured spirit in 1919 was only ₹2 per annum, irrespective of the quantity of the possession of a person. This rate continued to be in force till 1937. At this stage, it may be remembered that under the subsection 143 of the Government of India Act 1935, the provinces were authorized to continue to levy tax, duties, cesses, or fees which were being lawfully levied prior to the commencement of that act. Under the 1935 Act, as under our present constitution, the power to levy duties on alcoholic liquor fit for human consumption was allotted to the provincial legislature, whereas the power to levy duty on alcoholic liquor not fit for human consumption was allocated to central legislature. Denatured spirit, though an alcoholic liquor not fit for human consumption, the power to levy duty on the same was and is given to the central legislature. But the same being intoxicating liquor, the provincial legislature under the 1935 Act and at present the state legislature has power to levy fee. The power of any legislature to levy fee is conditioned by the fact that it must be by and large quid pro quo. So they relegated the matter back to the court that please look into it because whether it is a fee or not. And this issue was of license fee on denatured spirit, possession of denatured spirit. Rest is not a rest is on fee. What is fee and so on and so forth.
So they remitted it really on the whole question turned on fee.
Reasonableness. And whether it will be a tax or a fee. So
This is the one.
we kindly have para 12 then.
There's really no.
Distribution is belong to the state.
If they say it is an intoxicating liquor.
India have para 14.
In fact, they say therefore the duty, meaning thereby probably excise duty,
Excise duty.
will be levied by the center. But it's an intoxicating liquor, and therefore a fee can be levied by the state under 66.
And then in 12 said, let us see whether the impugned levy can be justified under as fee or not. That's it. That is para-
This sentence is, sorry,
Go ahead.
please.
So, Mr. Dwivedi, you see here the product that is being discussed in the judgment is denatured. That means it is made unfit for human consumption,
Unfit.
right?
Right.
So thereafter, although it starts off, the entire liquid, it starts off as an alcohol after molasses, it is made unfit for human consumption
By adding some.
by adding something. So that is fit only for industrial use. And we are looking at a kind of product which is alcohol and capable of human use. Is that
Quite-
what you are trying to?
Quite right. And I'm at the same time trying to indicate is not if denatured spirit, which is made unfit for human consumption, can be regarded by the Constitution bench as intoxicating liquor, then what to say of the rectified spirit, which is, it's not a denatured spirit, and we can't say it is as incapable of being consumed or not. Because not all that is needed in rectified spirit is that you put mineralized water into it and dilute the strength of the liquor from 90% to 35%, and it's drinkable. In fact, all over the country liquor is this only. There's nothing else. Country liquor is nothing but rectified spirit diluted by this demineralized water. So portability does not mean not having as it is. Portability, therefore, my submission would always mean that it must have some intoxicating element which may cause or is capable of causing intoxication. So it will include both, something which can be had as it is, plus what is capable of causing intoxication.
Then those who imbibe neat, would they be called purist?
Lord, by that definition, Lord, I do call myself a purist, Lord. Because I prefer single malts, Lord, therefore they can't be had. Lord, if to give an example, Lord, that's very interesting. I went to Edinburgh, Lord, that's a mecca of single malt. So I'm a lover of single malt. So I went to a bar. There I wanted to put ice cube into my single malt, which they served me. So the bartender got annoyed. He said, "You can't have this. I mean, it's a single malt. You got to have it neat. You can't mix it with water, soda, or cube. After all, ice cube is nothing but water." So he got annoyed. That's the first time I came to know a single malt is had like that. And there's a separate glass for it. It's not the normal whiskey glass. That's beside the point. I just do. The other is the Southern Pharma.
In relation to a human being.
In relation to, obviously.
So therefore it is alcohol fit for human consumption. Will it involve then industrial alcohol? Because industrial alcohol per se is not fit for human consumption.
No, as we pointed out yesterday, Lord, the legislative history indicated that both denatured spirit as well as potable alcohol were part of intoxicating liquor. All the excise acts, the Intoxicating Liquor Act of 1910 of Britain, the certain acts, Volstead Act of US, they all regarded the industrial alcohol as part of intoxicating liquor. In fact, the Spirit Act of 1870 of England was, they showed the awareness about denatured spirit. It is specifically mentioned as part of spirit. The local acts definitely mentioned it as intoxicating liquor includes denatured spirit. Because the reason is, Lord, as a Lordship saw in those definitions, all liquids containing alcohol are part of intoxicating liquor. That was the definition in all those acts.
Intoxicating liquor really, in your submissions, would include liquor which is fit for human consumption and liquor which is not fit for human consumption. Right? Because the intoxicating liquor in that sense in your submission is a broader concept, which is not confined only to liquor which is fit for human consumption. The only difference which arises is in regard to the taxing power.
Taxing power.
If it is alcohol fit for human consumption, the center has no control. If it is alcohol which is for human consumption,
then it goes under.
Then it goes to the states.
51 list.
If it is unfit for human consumption, the center can levy a duty, right, under entry 84. But the power of the state, once it falls under entry 8, the power of the state to levy a fee is preserved by entry 66.
To regulate. Regulatory fee can be imposed.
Whether in a given set of circumstance, a regulatory fee or something is is an independent determination.
Quite right. That's an independent issue. Now, Lord, there is an interesting question which I had posed yesterday slightly.
Please see Southern Farmer, since we were on it, so we close this part now.
Yes.
Volume 5, page 1985.
This is a judgment of 3 judges, Lord. Justice A.P. Sen judgment. And this is that deals with the industrial alcohol. ये तो पहले आ जाए. judgment would make more sense if a lordship would, this judgment would make more sense if a lordship would allow me for a moment to place the entry 51 list 2. List 2. This would make more sense, therefore I was going to that. Entry 51 says, duties of excise on following goods manufactured or produced in the state and countervailing duties at the same or lower rate on similar goods manufactured or produced elsewhere in India. Now, A is alcoholic liquor for human consumption, which means not what it means is there is an alcohol which is not for human consumption. That's one thing. Now, my apparent question is not if alcoholic liquor for human consumption is regulated under entry 8, where is the alcoholic liquor not for human consumption regulated? There is no entry anywhere. The word industrial alcohol is not used in the Constitution.
That point you made yesterday.
So it can come under industry as such. Under.
No,
Can
that's what
come
I
under
would.
entry 54 industry.
That is answered.
Subject to entry.
Let's assume at the moment it does. But I'll answer that.
Yes.
Now, alcoholic liquors for human consumption, there is no parallel entry with regard to alcoholic liquor not for human consumption. In any of the lists, if they were using this phraseology, then it was very convenient for them to have used the same phraseology, more or less, for regulating industrial alcohol, if the framers had that in mind. Then the more important part is, Lord, if your lordship would see, the excluding part, the last part. But not including medicinal and toilet preparations containing alcohol. Now, this part is excluded from the state jurisdiction only for the purposes of levy of excise duty. Because here also there is no legislative entry in any of the lists regulating the distribution, trade, commerce, etc. and medicinal toilet preparation.
Both are in.
So it was very convenient to have put a legislative entry in this regard also. And that is why Lord Southern Pharmaceutical says that these medicines and toilet preparations containing alcohol come in entry 8, following Lord Balsara. All liquids containing alcohol. Medicines containing alcohol, Lordship would recall, Lord, during time of prohibition, cup syrup was a very, very go-to kind of an object for most of the people addicted. They used to have cough syrups in large quantities and consume whatever alcohol was there in that. So, medicinal toilet preparations containing alcohol also fall in entry 8. And this is what Balsara said, and this is what Southern Pharmaceutical follows.
Point in that little
Yes.
extract from Southern Pharmaceutical, which says that.
Yes. And you have para 6 more, it's very clear. This is a case where the spirit was being used for manufacture of drugs, medicinal products. Para 4 contains the challenge. But this was not the case of idea. 6. Enactment of Medicinal Toilet Preparations Excise Duties Act 55 by Parliament under entry 84, list 1 of the 7th schedule to the Constitution, or the framing of the Medicinal Toilet Preparations Excise Duties Rules 1956 by the central government in exercise of their rule-making power under Section 19 of the Act for purposes of the duties of excise on medicinal and toilet preparations containing alcohol, etc., do not prevent the state legislature from making a law under entry 8, list 2 of the 7th schedule to the Constitution with respect to intoxicating liquors or a law under 51 list 2 for levying excise duty on alcoholic requirements for human consumption. In order to appreciate the contention regarding the applicability of the doctrine of occupied field, it is necessary to examine the scheme of both the acts.
Yes, this is also clear.
Then 8. Legislative history of this central act, I'll omit that, but I'm sorry, I will be. Para. Good.
Element.
I would pray, Lord, kindly have it from para 12, 13, and 14. It is the charging section which gives the true index to the real character of a tax. The nature of the machinery by which the tax is to be assessed is not of assistance, except insofar as it will throw light on the general character of the tax. The charging section in section 3 of the Central Act clearly shows that it does not seek to levy a duty of excise on alcoholic liquor for human consumption falling under 51 list 2 of the 7th schedule, but to levy a duty of excise on medicinal and toilet preparations containing alcohol, etc. This is the central rule. Last line, last 2 lines, but there can be little doubt that the Central Act must in pith its substance be attributed to entry 84 list 1. In determining whether the enactment is a legislation with respect to a given power, what is relevant is not the consequence of the enactment on the subject matter, or whether it affects it, or whether it is in pith and substance. It is a law upon the subject matter in question. The central and the state legislatures operate in 2 different and distinct fields. The central rules to some extent trench upon the field reserved to the state legislature, but that is merely incidental to the main purpose, that is to the levy of duties of excise on medicinal toilet preparations containing alcohol. Similarly, some of the impugned provisions may be almost similar to some of the provisions in the central rules, but that does not imply that the state legislature has no competence to enact the provision. It is sufficient to say on the first ground that the impugned legislation is confined to intoxicating liquor, that is to ensure proper utilization of rectified spirit in the manufacture of medicinal and toilet preparations. And therefore, within the power of the state legislature under entry 8 list 2. It further seeks to regulate the manufacture of bona fide medicinal preparations and prevent misuse of rectified spirit in the manufacture of spurious medicinal and toilet preparations containing alcohol capable of being used as ordinary alcoholic beverages. It was suggested that the provisions are identical with the provisions contained in central rules, and in particular Rule 45(1), and therefore the legislation is in the occupied field. The answer is that the enumeration of intoxicating liquor in entry 8 list 2 confers exclusive power to the state to legislate in respect of medicinal and toilet preparations containing alcohol. But perhaps that answers Lord Justice Lord Nagarata's query. The exclusive power cannot be taken over under 2024. That's what we are expanding this argument. The exclusive power of the state under entry 8 or entry 25 list 2 is exclusive power, is carved out of the general power of industry, entry 24. And therefore, that exclusive power cannot be at all taken by the center by making a declaration under IDR.
In other words, Mr. Dwivedi, your argument really would be this, that the bifurcation in regard to the legislative competence of the center on the one hand and the states on this subject is in respect of the levy of the duties of excise. Right? So what the centralist does is that the power to levy duties of excise on all goods produced or manufactured in India excludes alcohol fit for human consumption. That is a central list, entry 84. Alcohol, which is duty of excise on alcohol, which is fit for human consumption, which is taken out of entry 84 of list 1,
Goes to-
is given to the states under entry 51 of list 1, of list 2, right? So this is the bifurcation in regard to the taxing power. Now, insofar as the substantive power to regulate is concerned,
There is no division.
there is no division at all. The only reference to the substantive power to legislate on intoxicating liquor is in entry 8. And entry 8, therefore, would cover the broad gamut, whether it is fit for human consumption or unfit for human
All
consumption.
liquids containing alcohol.
But even though you have the power to regulate it under entry 8, state cannot levy the duty of excise on alcohol which is not fit for human.
There is another factor, but supposing
It's
I levy,
pretty clear, right?
I levy a fee which is very harsh and excessive. Then lordships can turn around because regulatory fee is to recover the cost of regulation. But then if it is very high and very harsh, then it becomes a levy which is generally to churn out revenue, which is then becomes a tax rather than a fee.
Those are independent challenges.
That's the question. And that's an independent question. We're not concerned. Just as in synthetics too, they came to a finding that the levy imposed there was vend fee on rectified spirit or denatured spirit. And their lordships felt and came to the conclusion that the levy is excessive. So they said it's a tax. And if it is a tax, then they said that there is no power in the state list to tax the rectified spirit or denatured spirit, except in 51, which is excise duty. There's no other power. Taxing power has to be expressly given. So they are separate. So therefore, they said there is no power enabling the legislature to tax rectified spirit or denatured spirit. Therefore, that levy is bad because it's a tax. So that question in that decision note turns really on this.
And there is no substantive provision in list 1, either dealing with alcohol which is fit for human consumption or unfit for human consumption. Surprisingly, not surprisingly, but list 1 is advisedly silent in regard to that. There is no specific provision in list 1, except in regard to taxing. And therefore, taxation is a completely different thing.
So therefore, the question is, when they were dividing the object into two for the purposes of tax, were they oblivious of the fact that there are two separate categories? The fact is they realized that the intoxicating liquor containing alcohol is included. All liquors containing alcohol are included in entry 8, intoxicating.
And look at the beauty of the constitutional division. Just as a aside, entry 24 of list 2 covers all industries.
All industries.
Right? So the entire gamut of industry is governed by the states under entry 24 of list 2, except whatever is declared to be a controlled industry under entry 52. Yet, though the state has full regulatory power on industry, you can't impose a duty of excise on any goods produced by your industry. The power to impose the duty of excise is given only to the center.
But there was a reason for it. Not I went into that issue. Why is this? But the reason is primarily because India had become independent. Now it required funds, huge funds, and excise was the biggest revenue churner at that point.
They wanted to give it to the center.
That they wanted to go to the center.
To also have uniformity. Uniformity with regard to rate of excise.
Right.
But there is no substantive provision in list 1 dealing with either alcohol which is fit for human consumption or
even medicinal toilet preparations containing alcohol.
The only reference we have is to intoxicating liquor in entry.
Only. That's right. There is another interesting factor. (17) of the southern pharmaceuticals. That's also interesting because they again fall back on Balsara. Madam. But Lordship, just make a note of it. That is reliance placed on Balsara.
So Balsara is approved again.
Yes.
Slightly different.
Again, the issue is all liquids containing alcohol.
Sleep all.
There is a little more interesting factor which I may bring out to Lordship's appreciation. And that may further clarify the position. Lord, let us
We are at 11:30. We've understood now your point and you've made it very succinct.
I'm grateful, Lord. Lordships
Now
have not.
call upon Mr. Datta.
But then since Lordship, as Solicitor said, Lordships have sitting in high judgment, which is not a recurring kind of a thing.
Why don't you do this, Mr.
There is something important which I want to point out.
One more thing which we would like you to do is that obviously because you are arguing in the flow of the submissions, we ask a question, then you cite a judgment.
Quite.
Just on maybe one page or 2 pages, just in chronological order,
It's there in my written submission,
There's no
in the
difficulty.
chronological
Then of
order.
course we'll have
But
PhD.
this aspect is something which becomes a thought-provoking idea, comes not when we are researching, thinking over it, then it comes up.
All right, now
This is what I wanted
tell
to
us
submit.
what more.
Yeah.
What more?
Not apart from the fact that the industrial, this intoxicating liquor has been expansively read because of the legislative history and the legal sense. Now, if your Lordship would recall the Lordship's query yesterday, is there a conflict between entry 52 list 1 and entry 8 or entry 25? And my answer is there is no conflict.
According to you, once it falls under entry 8, it
Or
can't
25.
go into entry 24.
It
And
can't
if it doesn't go into entry 24, it can't go into entry.
The reason being, Lord, the source is 24. The power under 52 is not like entry 97, residuary power, where everything can be dragged in. But source is there for entry 24, that for entry 52, that is entry 24 only. So it can't go beyond entry 24. If entry 24 does not contain something, then it cannot be contained in entry 52. And that is the reason why ITC struck down the central law, Calcutta Gas struck down the central law, IDR. That is the reason why McDowell strikes down. That was a case where the declaration was made with regard to even potable liquor.
Right. Really speaking, the universe of industry is contained in entry 24.
Wow.
What entry 52 does is, it carves out a portion of what would otherwise fall in entry 24 by allowing Parliament to make a declaration.
Wow.
So what is left in 52 is, or rather what is taken in 52 is that limited area where Parliament makes a declaration. Anything which is not covered by a declaration by Parliament does not come into 52 but comes into 24.
That's one aspect, but I'm grateful. The other aspect is not what
But before Parliament makes a declaration, it must otherwise fall under 24.
under 24.
If it doesn't fall under 24, what's Parliament making a declaration under 52 about?
The difference being entry 97 doesn't have a source, but entry 52 has a source and therefore is limited, unlike entry 97. So we can't